An estate agent wants to view the home you've lived in for 22 years. Your late partner's children are trying to arrange a sale without asking you. You're still in the house, your clothes are upstairs, your post still comes through the door, the neighbours still know you as the couple who've lived there for years. But the request isn't asking whether the relationship was real. It's asking when the property can be valued, photographed, and prepared for sale. Karen was in that position after her partner Malcolm died suddenly after a short hospital stay. She lived in the same three-bedroom house near Chelmsford for 22 years. They weren't married. She'd paid £650 a month into the household account, dealt with the utilities, and over the years had put about £14,000 towards kitchen and the roof works. So when Malcolm's two adult children started dealing with this estate, Karen didn't expect the house to be treated as if it sat outside her life. Then the agents asked for access. Karen was still living there, but someone else was trying to give the agent dates. That's the difficult gap for unmarried couples. The home can feel settled without while control of it sits somewhere else. Karen had the same GP address as Malcolm. Her bank statements, prescriptions, insurance letters, and day-to-day life all pointed to that address. There wasn't a spare flat or another house waiting for her. There wasn't an agreed moving date. There wasn't a quiet plan that she'd leave if Malcolm died first. But after the funeral, the conversation moved quickly into administration. Malcolm's children wanted to know what their estate was worth, the agent wanted access, and a sale was being discussed. And Karen still had to sleep there that night. 22 years of living somewhere doesn't automatically make you the person with control over the property. Shared bills don't automatically put you on the title. Being treated as a permanent couple doesn't automatically give you the inheritance position of a spouse. The home she'd kept running became a property someone else was preparing to sell. The agent needs access, the children ask for timescales, the bills still arrive, Karen's belongings are still there, and she doesn't yet know whether she can refuse, negotiate, or stay. Malcolm's children aren't automatically right. Also, Karen isn't entitled to remain there indefinitely either. In cohabiting partner estates, the early pressure is often possession, who's being recognised by the agent, the executors, and the buyers, and what the survivor can point to when asked to leave. For an unmarried partner, staying in the home after death depends on provable rights and recognised authority, not on how strong the relationship looked from the outside. It isn't asking Karen to prove that 22 years mattered emotionally, which of course they did. It's forcing a property control answer before Karen has had time to work out the answer. The first issue is access. An estate agent usually isn't deciding who deserves the house. They're looking for someone who appears to be able to deal with the property. That might be an executor, it might be someone entitled under the estate, it might be a beneficiary pressing for the property to be sold. If Malcolm was the sole registered owner and his children are dealing with his estate, the agent may treat them as the people to speak to. The second issue is the title. If the land registry title shows Malcolm alone as the registered owner, Karen starts from a different position than she would if the property were held jointly with her. Living there for 22 years doesn't by itself add Karen's name to that title. Paying the gas bill or arranging the council tax doesn't by itself change the title or make her a co-owner. Those facts may still matter, but they don't all do the same job. That's why records matter. They help decide whether Karen has a route to resist the sale or whether she has to build that position with evidence. The third issue is where Malcolm's interest goes through the estate. If Malcolm had a will, it may say who receives his interest in the house or who has authority to deal with it. If he didn't have a will, intestacy rules don't treat an unmarried partner as a spouse. An unmarried partner doesn't have the same automatic inheritance position as a husband, wife, or civil partner. In this case, without a will, Malcolm's estate would point to his children and they may believe they're entitled to push the sale forward. Karen's answer then can't just be that she lived there with him for 22 years. She needs something that answers the property position. The fourth issue is proof. Karen's £650 a month into the household account has to be understood properly. It may look very different if it was ordinary living costs, support, rent, or a contribution towards the mortgage. Her £14,000 towards the new kitchen and roof works also has to be tied to a trail. Payment records, invoices, and messages from Malcolm about the house being shared, protected, or repaid may all change how the viewing request is answered. A beneficial interest is where someone may have an interest in property even if they aren't on the title because of contributions, agreements, intentions, or other evidence, which this could potentially be the case for Karen. But it's fact sensitive. It has to be supported by strong enough evidence. There can also be a separate route where the surviving partner was financially maintained by the person who died or has a housing need connected to the relationship. In some circumstances, a claim for financial provision from the estate may need to be considered, but that doesn't freeze everything automatically. For Karen, the viewing request isn't the final legal verdict. If you're unmarried and living together in a home that one of you owns, test who would actually control the home if one of you died. Put the viewing request at the centre and use 4 control points. Confirm who can instruct. This is about the person recognised by agents, buyers, and the estate administration process. If one partner dies, the sale process will look for someone who can speak for the property, give access, and provide vacant possession. Confirm whose title it is. A sole owner home gives a different starting point from joint ownership. If the title doesn't match the way you talk about the home, that gap needs attention. Karen could live there, receive post there, and help run the household while still being absent from the registered ownership. That is why the title has to be tested against the life actually being lived in the property. And map out the estate route. A will may give the survivor a right to stay, a share, gift, a trust arrangement, or an option to buy out. Without a will, intestacy may send the estate in a direction you never discussed or wanted. And even with a will, the wording has to deal with the house as it's actually owned. For Karen, this is where Malcolm's children may appear in the sale process without the viewing request being the final answer. So gather evidence that answers back: bank statements, mortgage contribution details, renovation invoices, messages about ownership, promises about staying in the home, evidence of financial dependency. For Karen, those control points can change things. If Malcolm was sole owner, the title starts against her. If his will or intestacy points to children, their state route may also start against her. If her payments were mainly just for food, bills, and ordinary living expenses, those may not be enough on their own. But if she paid towards the mortgage, funded major works, and has clear messages showing Malcolm intended her to have a stake or a right to remain, the position may become more complicated or clearer for Karen. That's why a quick sale demand can be too fast. The survivor doesn't automatically win, but the sale can't be treated as purely administrative if there's a serious property or provision issue to resolve. The viewing request asks for a date. The title shows the ownership starting point. The state route shows who may control Malcolm's interest. The evidence shows whether Karen has a right to claim or negotiating position that has to be dealt with. If you separate them, the risk becomes much more manageable. You can decide whether the survivor has a right to stay. You can decide whether there should be a life interest, a trust, a share of ownership, a buyout mechanism, or a clear written agreement. You can decide whether adult children are meant to inherit later or immediately. The detail has to fit you and the property, but the decision itself needs to be made deliberately. Karen's difficulty was that possession and control hadn't been settled clearly enough. If you're unmarried and the survivor's ability to stay would depend on someone else's children agreeing, test the home position now. Who can stay, who can sell, who can buy out, and what evidence supports that arrangement. Decide who controls the home while both can speak.